Okay, everyone, I can see attendees being admitted. We're just sorting out getting the PowerPoint on screen for you as well, but you'll be pleased to know it's not too many slides. In fact, it's two, given the nature of this seminar that we're doing today. So if you just bear with us whilst the attendees are all coming in, and then Sam will get us up and running. Right, we're at 1 minute past 1 and it looks as though our attendees, oh no, they are still going up a little bit. Apologies. I found this with a number of Zoom webinars that you can't admit people any quicker by any other way. And that was a really bad thing to find out when we started on time with over 400 attendees in a recent business and property seminar that I was running. And we had to wait for about 10 minutes until the numbers started going up. But you live and learn.
Well, and of course, not having slides to go through in the same way means if people are a bit late, they don't necessarily miss things in the same way. So.
Yeah. Right, I think the numbers are probably about balanced out. So whenever you're ready, Sam, shall we crack on?
All right, well, good afternoon, everyone. Thank you very much for taking the time out of your day or probably just staying in the same place that you were this morning, but the only difference being with a sandwich and a cup of coffee. What Laura and I wanted to talk to you about today was our year of lockdown, what we've learnt, what our tips are for the experiences arising from things like CVP and what we expect over the next 12 months. So we just start with a bit of an introduction. So I'm Sam Prophet, and if you've seen the profile that went out with the webinar, you'll know that I've only been at Chambers for a couple of weeks. Spent before that 9 years at DSC Beechcroft as a solicitor and then later as a solicitor advocate. So done lots of advocacy. I've seen both sides of the fence, as it were, over the last year. But delighted to have joined King's, and I can see from the attendee list there are some familiar faces, but some unfamiliar faces and names as well. I'm looking forward over the next little while to getting to know other people, but of course joined today by Laura, my far more experienced and capable colleague. Laura, I'm sure you know everyone on the attendee list, but do say hello as well.
Yes, good afternoon, everyone. Thanks for joining us. I probably do know most of you. For the few that I don't, I'm Laura Gould. I've been a barrister in the employment team at King's Chambers for something like 10 years now. I've stopped counting. It doesn't seem like a fun thing to do anymore, to keep counting those years, but I've been practicing predominantly in employment law throughout that time. I do some commercial employment, general commercial and insolvency work and sports law work now, but it all really flows from the employment work originally. And we're delighted to have Sam join the team and to congratulate him on his first win yesterday, a very hard fought battle where he was lucky enough to actually get the decision as part of the hearing, which we'll come on to explain seems to happen less and less these days. So congratulations to Sam. We're really pleased to have him in the team. We know how good he is, having been our instructing solicitor for, well, throughout his time at DAC Beechcroft. And I hope that we can both give you some useful insights into what's been happening. And I'm sure you're probably particularly interested in what we think is going to happen over the next 12 months of work in the employment tribunals.
Yeah, so I think this session is really about sharing those experiences, because the last year, of course, has been such an evolving process in the employment tribunal. And there's learnings to be shared. There's learning from the judicial and the tribunal side. There's learnings amongst barristers. There's learnings amongst lawyers and the clients. So Katie, if we can have the next slide so we can see the what our agenda is for today. So we're going to keep it quite loose, and I think that reflects what the new normal is really. You know, we're not sitting or standing in front of you in our tribunal where with 30 slides of authorities that you'll never look at again. We essentially want to have a discussion between ourselves so that you can hear about our experiences over the last 12 months, what we think we're going to have over the next 12 months. And some of the topics we're going to cover on the agenda there, but that's the extent of it. But you'll have seen part 3 questions. Please do put in your questions into the Q&A. When we see them, if we've got an experience that we can share, we'll do so. And if we have some time at the end, then of course happy to take some questions as well. So what have we seen? Well, if I kick off in terms of my experience, which, as I say, crosses the divide from solicitor to barrister. I think if there was a graph of the hearings over the last 12 months in the Employment Tribunal, it'd probably look a bit like a graph of the Bitcoin price. It was absolutely rock bottom at one stage, particularly March and April last year, nothing happening at all. But we now know that the capacity of tribunals is massively higher than it was pre-COVID. I remember one of the few times that I was actually in tribunal in person late last year, went to Manchester, and as I usually do, had a look on the board. Typically expect pre-COVID to maybe see 8 cases on the board, something like that. But I remember seeing 27 cases on the board for that day, yet I was the only person who was actually there in person in the tribunal, which gives you an idea of the scale that the tribunals can now handle in the new normal. Some of you may have seen November last year, Barry Clark, the ET president, gave a talk with Daniel Barnett. It's quite good. You can find it on YouTube and it's worth a watch. But he talks about CVP being the minimal viable product for hearing cases post-COVID times. And although it's the minimal viable product, they are going with it for now because there is such a massive backlog. He explained that there were now over 300 CVP rooms available to the tribunals. And those of you who have a national practice will know that that is a huge amount of potentially available rooms to hear cases. And it's far more than the physical room setup that they previously had. He also said that he wants to increase the number of physical rooms, but of course that's going to take longer, and it will be reflected in the guidance that comes out about whether hearings should take place in person. He also said that there would be a new version of CVP. It's currently being piloted. I haven't used it. Some colleagues may have done. But I think what is clear is that parties and tribunals are really getting to grips with the new normal of CVP. And we know now that the disposal rate of hearings is back to pre-COVID times. But because of that backlog, there are far more claims to deal with, and it's going to take a while to get through them. The other thing I saw recently was the Employment Tribunal quarterly statistics up to December 2020. And that showed that in that quarter, there were over 13,000 single claims received, which I understand is the highest since 2013 before the fees came in. And the number of single claims outstanding was over 44,000, which is the highest since 2009. So I think overall what we've seen is, and what you will have seen as well, of course, is a massive decline followed by a massive increase. Now, those of you who have a regional practice will probably have experience particularly of a tribunal region. But what we can say and what we know we have seen is that there is a massive difference in regions. Now, some of those regions are now caught up in the sense that full hearings can be listed within a few months, particularly the Scottish tribunals. If anything, they're listing hearings too quickly, and that creates a problem in terms of getting things ready. But particularly London tribunals, we're still looking 12 to 18 months, and there's a real difficulty of clearing that backlog. But I think where we are now, a year in lockdown in March 2021, is that we have to assume really that everything is CVP unless we're directly told otherwise. And I know from my time as a solicitor and also having moved across as counsel is that the tribunals, particularly the ones that are under those significant administrative backlogs, they're often not telling us until a day or two before. But I think the question as to whether it's CVP or not remains to some extent a binary one. And that is it literally possible for this hearing to be done by CVP in light of the ability of the parties? And where it's not, what we're seeing quite often is hearings are being postponed. There are a few examples of hearings going ahead in person, but they're pretty scarce still. But I think what is clear now is that having had 9 months or so of CVP, parties and tribunals are able to deal with really quite complicated hearings, full hearings, long hearings via CVP. Asked around the group in chambers before we started about examples of longer hearings. We've got loads of examples of 7+ day hearings, complex hearings, lots of witnesses. The length and complexity of a hearing doesn't now seem to be a barrier to whether or not it can be dealt with by CVP. I think where the tribunals are dealing with things not by CVP, it needs to be that there is a real impediment to being able to actually deal with the hearing. Things like an inability to communicate, whether that's disability related or technology related. I recently had a case where a claimant said, I can't do CVP because I've only got one laptop and my son needs it because of homeschooling and they couldn't afford another one. So asked for it to be held in person. Now, that was ultimately resolved. So it wasn't a question that the judge actually needed to deal with. But I think that creates quite an interesting set of circumstances. I'll come on to later a little bit about how parties can prepare and prepare for contingencies. But one of the potential ways in which parties can react to circumstances like that is, well, if you're a respondent and you're really desperate for this hearing to go ahead because it's been 2 or 3 years down the line, there might be some creative solutions that could be presented or offered in a situation like that. So if you really want this hearing to go ahead and the claimant is saying, look, I just don't have a webcam or I don't have a laptop, is it in your interest to potentially offer that? Maybe it's a good idea, maybe it's not. But these are the sorts of creative and new issues that I think we've seen over the last 12 months or so. Laura, share with us a couple of examples of what you've experienced over the last year since the days of CVP.
Sure, and I think that's a really good overview, Sam. So I don't want to repeat what you said because you've really hit the key points on the head. But certainly an anecdote from Scottish Tribunals listening to you recently. I've just finished it was 3 days, listed for 3 days, but then we had an extra half day for submissions. Seems like rather a long time for an unfair dismissal case, but it got used. And that was listed with about a month's notice. And the prep was affected as a result. And interestingly, they actually required us to produce witness statements. Now, the claimant in that case was dyslexic, but I didn't necessarily get the impression from the preliminary hearing notes. I wasn't at the preliminary hearing, but I didn't get the impression that was necessarily just because the claimant was dyslexic. I got the impression because we were doing it by CVP and doing it at short notice, that was also part of the reason why we were using witness statements, which obviously is what we are more used to, but doesn't usually happen in the Scottish Tribunal. So yes, they really can list quickly, but I've had to book out my holidays for spring next year because I was booking in a trial in May. And so wanted to make sure I got the WIT week booked off. That's how far ahead we're having to look. And so I think if you are coming to a point of looking at a potential adjournment because you're not ready, because someone's ill, because someone's shielding, and this is one of the options, you need to bear in mind which tribunal are you asking that for, because if it's Cardiff, you'll be in by the end of the year for 3 days. If it's Leeds, you'll probably be in quicker, actually. If it's Scotland, you'll be fine. But as Sam says, if it's London or Manchester, you are looking well into 2022 now. In terms of some examples, I have had issues where the claimant has not been able to appear on CVP initially. We did manage to get it resolved, but we arranged a room at an NHS trust for them. I think we have actually done that on another occasion where we followed through with it. I've had the same done by a local authority, albeit for someone who was still employed, but would not be in the workplace for furlough/shielding reasons if it wasn't to attend the hearing. I have heard examples from colleagues where with hybrid hearings, which I have found now any attended hearing is likely to be a hybrid, whether it's just that counsel attends or counsel and the claimant in person, and all the witnesses are by CVP or certain witnesses are by CVP. I can only think of one case since last summer where we've all been in person. And I think I only had one witness and the claimant was representing himself. And the judge ended up delivering a written decision anyway because the claimant was having to travel from Hull to Leeds because Hull Tribunal wasn't open and he didn't want him coming back just for the sake of judgment. So where we've got hybrid hearings, I have heard of counsel being in person for one side and being by CVP for another side. I personally wouldn't be comfortable with that in anything other than the most extreme circumstances, and I would imagine clients wouldn't be. I did on one occasion have myself and claimants counsel and all of our witnesses on CVP after he'd got one of these phone alerts saying you have to isolate, but his client still went the next day to observe, and there was a fair bit of back and to from us about that, and I made sure that she was sat in the witness box so could be seen on screen because she was prone to speaking up. Not in any untoward way, she just wanted to say her piece. And again, I wasn't comfortable with the potential that the tribunal was seeing her mouthing things. I don't think it would have affected anything, but it's about justice being seen to be done as well. So there are certainly so many different permutations of how these hearings can go ahead. I would agree with Sam that the tribunal have got much better at it. And so the technological issues that we had in the first instance are starting to reduce, but they've not gone entirely. I had an injunction hearing last week, and my opponent was having all sorts of difficulties with her Wi-Fi, then her computer shut down, and she had to open a different, on an iPad, I think it must have been. Then the sound wasn't working there, so she had to plug in the headphones. And she's done plenty of video hearings. It just went wrong on that day for her, and I really empathise. So they're not problems that are entirely solved yet, and I think we'll come on to some tips in terms of clients, witnesses, CVP. But I would also say that in terms of the future and what we've seen so far, it's not just the tribunal that are doing lengthy hearings by CVP, and I think that indicates the approach of the judiciary generally and where we can expect to go. I was speaking to one of my solicitors yesterday who does commercial and chancery work, and he'd just finished a 2-week trial in the Chancery Division in Manchester, I assume from the judge he named. 2 weeks property trial by CVP entirely, and a 2-week trial in property work is far less common than it is for us in the tribunal. And so I think the fact that those courts are getting on with this as well is a sign that people really have adapted and are going to be keeping this as something that we use into the future for exactly the capacity reasons that Sam's already described. So it's certainly happening as Sam describes, and I would expect it to continue in that vein. So when we come on to hints and tips, I have had people tell me recently that they're only just getting to their first CVP trial going ahead because of the change in work last year and because then a case is settling or still getting pulled. It's worth getting on board with the tips that we're going to give you, and you will hopefully find helpful, because it's not a case of lockdown restrictions lifting in the spring and this is all going to go away.
So thinking about that background and our experience, what we want to do is, by way of partly of anecdotes and partly of what we have learned and what we've shared with ourselves, is to give you some ideas about tips and how we can learn to better prepare cases. And ultimately, a better prepared case, it might only be a 1 or 2% increase, but it ultimately will help you win a case. And my headline in that respect is really about anticipation and preparation for the contingencies. Now, of course, an in-person hearing, you've got to make sure everyone gets there. You've got to make sure the papers get there. But once everyone's there, we should be all right. Okay, odd things might happen, but those are the two key issues. Whereas I think what I've found over the last year is that the number and the range of things that we need to prepare for, those contingencies, are much greater. So if you've got 10 people across the tribunal panel, counsel, solicitors, witnesses, that's 10 people that can have the sort of unpredictable tech issue that Laura talks about. And I think that the way to learn and the way to cover that off is anticipation and preparation, making sure that when those issues happen, firstly, that we prepare for those issues, but then also when those issues happen, we have another way to work around it. So an immediate and obvious example, I think it's a really good idea for witnesses giving evidence to have both an electronic bundle and a paper bundle, because that covers off two issues. One is if there's something that goes wrong on screen, they've got a paper bundle they can refer to. But also witnesses are very often, it's the first time they've ever done anything like this. And the process of speaking to a person, having documents open electronically, perhaps needing to go to a witness statement and a document and talk to person. It's very difficult to do that if you've not practiced, you've not done it before. I mean, I have full screens in front of me. I don't expect a witness to have full screens. I don't think a witness needs full screens, but more than one is helpful, but at least more than one environment where they can see what they need to see is definitely helpful. I think spending more time with the witnesses about what's going to happen is a good idea. You know, we do that anyway, of course, with any hearing, but the ways in which something might go wrong on screen and how they might sort it, you know, how to organize their documents on screen. If they've got the hearing bundle and 3 different witness statements, you know, having those PDFs separate but accessible, you know, talking through that in quite significant detail with them so they feel comfortable. Now, these issues are always going to arise, and my experience is that judges are, you know, quite understanding, certainly at the moment, of when these issues arise. But just as somebody in an in-person hearing can be late because a train is delayed, I'd much rather the other side was the person who was late, just as I'd much rather the other side was the person or the set of people who are having difficulties. So the extent to which we prepare and anticipate those things is going to reduce that. I think to some extent it's particularly important to do that on the respondent side. And it's always been the case, or has been since I've practiced anyway, the respondents tend to be held to a higher standard when it comes to things like preparing bundles and making sure the hearing is ready to go. They typically have more experience. They're typically legally represented, where claimants often aren't. And I think what respondents, or whoever is taking care of the bundle in particular, needs to really think about is an investment in good IT and good IT training, because there is a huge difference between a good electronic bundle and a bad electronic bundle. You know, a bad electronic bundle is basically just a series of PDFs. They might be numbered, they might not. They're massive because they haven't been shrunk. A good PDF bundle, there's some good guidance, and particularly from the High Court, and the Supreme Court also has its own. But a good bundle includes things like optical character recognition, so that you can search the bundle for words. Now, you need particular type of PDF software in order to do that. And you also need to have quite a powerful laptop, because otherwise it will take the system 10 hours to do it. But if you've got a powerful laptop, you've got good software. I recently did that for a bundle which was massive. It was 100 and something megabytes, which I know you know about that stuff will know it's a really big bundle, and it took seconds because I've got the software and I've got the equipment to do it. And I think that to some extent comes down to the individual ability. You know, how much training have you had in terms of how to create an electronic bundle, but also your IT equipment as well. Thinking about bundles in particular, hyperlinks, bookmarks, reducing it so that it can be a single PDF, that's all sensible and that's all going to help. But I think a particular change in approach to bundles is helpful, and that is to forget the historic practice of adding documents chronologically. Now, we all know it's inevitable that after the bundle has been paginated, there will be more documents. And the old way to do it was, where is it in time? Put it in ABC. And that's perfectly sensible when you've got a hard copy bundle, because it may well be that you don't want to flip 500 literal pages to get to the other page. But with an electronic bundle, if you stick that document at the end, it only takes a second to click to get to that document or to type in the page number. So the fact that it's not chronologically where it would have been isn't a problem. But if you do try and slip it in ABC, it throws out the PDF reader numbering, and that makes the PDF bundle, the electronic bundle, gate. And part of this process of anticipation, of preparation, is to ultimately to help the judge, help the witnesses, and help us navigate our way through the case at the hearing. And that's one of the things that I think, as I say, is a quite a significant change to the normal approach, but actually is one that I absolutely recommend. A couple of minor things that I've sort of picked up on, one particularly in the hearing that I did yesterday, is we're always told with CVP links to use Google Chrome. For some reason, Google Chrome works better or has fewer issues than Internet Explorer or other browsers. And there's 2 points there. One is, firstly, in my experience, witnesses will often say, oh yeah, I know Google Chrome, but what they actually mean is Google search engine, and they'll end up searching Google in Internet Explorer. So go through that with them clearly and make sure they know that Chrome is the browser. But also, even in Chrome, it seems that you can sometimes have some sort of weird settings issue, which means the camera doesn't work, or the microphone doesn't work, or something's going wrong. And what I found yesterday is that if the CVP link is done through Google Chrome on incognito mode, which is a different mode that you can do, it's in the top right hand corner, that seems to wipe the settings, and it seems to then correct the difficulty between the camera and the microphone. And that's something, as I say, I learned for the first time yesterday. And had we not realized that yesterday, my witness couldn't get the video to work. And the judge was at the point where he was saying, right, if we can't get this work, we're going to break for an hour. You, witness, need to go and find an office, which was about an hour journey in total, to get a new setup. Now that would have been really problematic. It causes delay, means the witness is flustered, and by the time the witness had got to a new approach, there's a new place with a new laptop, there's no telling whether or not that would have sorted it. So it's those sorts of things that we can anticipate and prepare to make sure the hearing can go ahead properly. The final point that I would say is the way in which you communicate through CVP, through Zoom. Now, you'll have all seen this from the meetings that you have held with each other and with clients, but it's far easier to hear and be heard if you have some sort of headset, rather than speaking through the computer. Now, to some extent, that's personal preference, but again, the experience that we had over the last couple of days is claimant in particular didn't have a headset and was just talking to the laptop. And the problem is microphones through laptops tend to be unidirectional. So as soon as you turn away from the laptop, you lose the sound, and that means the question isn't heard, the question needs to be repeated, the witness doesn't hear, the witness needs to hear it again. Whereas if you have a headset of something, headphones, it doesn't have to be anything particularly fancy. It means, as I say, you can hear, you can be heard, you can communicate better, and that means the hearing is going to go smoother. Laura, top tips, CVP.
Again, you've hit the main ones on the head, so I'll just try and add to that. I've found now there are at least, I would say, 3 different ways for us to access CVP. Same as you get different tribunals saying, we'll ring you for a telephone hearing, or you've got to ring us. And sometimes it's the 0330 number and sometimes it isn't. That same sort of problem is happening with CVP. I don't know why. Same issue for all of you guys in terms of prepping bundles. Tribunals still have different approaches. It's frustrating, but unfortunately, it's what we're dealing with. I would therefore advise any witness to practice joining the CVP on the sort of trial link that they give you when they send out the instructions, because even if they've had it work in the past, say it's a HR person who attends a number of hearings for a large employer, doesn't mean it will work or that they will be comfortable finding the way in through the new system. I would also say with one of those options, some will take you straight through to the CVP page, which we've probably all seen by now, but some will take you to one where it says join via Skype for business. And then if you scroll down the page, it won't always come up depending how big your browser is. It says join by web browser. I use an iPad and I use Safari. I haven't had the Google Chrome issue through iPads. But I found joining through web browser is an awful lot easier, and it will just then, as I say, take you to the usual CVP page. When you are signing in, don't just put your first name, which I saw a witness do recently. And it helps if you put your title, so you Mr., Miss, Ms., MX, whatever you want to be used, and then say comma, and I would say counsel for R or R1. Or occasionally counsel for C, and I have to remember to change that. But if you can say witness for R or dismissing officer or something like that, it's so much easier for the judge to control. Then once you're in the hearing, it's the judge who has to let you in once the clerk has gone. In most instances, there are some times where the clerk's still doing it, but usually not. And so if you keep dropping out, or you need to log off and log back in, it's going to distract the judge. So if you've left and tried to come back in a couple of times and can't, you'll need to get on email to us, and chances are you'll have an email chain with us already to let us know so we can explain to the judge, apologise, try and get it sorted. If you need to go and use the CVP helpline, I haven't used it, but from my experience of clients using it, and the other side actually, it seems to be very effective. They're very quick, they're very responsive, they get it sorted, but it's far better if you've done that in advance. That's particularly so because now, especially if you've got a judge sitting alone case, we don't have the reading time that we used to have. The judge will have done the reading in advance because you've sent the bundles in advance, whether that tribunal quarantines them or whether that judge uses the electronic bundle. Doesn't happen so much with wing members, but you cannot count on that reading time on the first morning that we used to always know was going to be available. So it is worth doing that prep in advance. Still put the sign on the door. I've got one on now. We'll see if the Amazon delivery man abides by it or not within the next 8 stops, as the alert has just come through. But at least if you can say, I did put a note on the door, any embarrassing interruptions are made easier. Couple of tips for the bundle prep in addition to what Sam said. When you're adding documents at the back of the bundle, just have a section called additional documents, something like that. And it makes it far easier then for sending a collated set of additional documents to the tribunal at the end of your preparation, ready for the hearing. I actually found yesterday, day before, something like that, when I was having to do this, that if you open the document in PDF Expert, which is what I use, I was able on my iPad to write in the page numbers in the bottom right-hand corner, which and convert them to text. So rather than worrying about renumbering the whole bundle or how do I start it at page 293, I could just write it in. So if you have access to that, if you're using iPads with your work, that's a really, really good program to use. Main top tip though with bundles, at least as valuable as the A, B and C, is incorporate the index into the bundle and paginate the index. So have your index separate to start with. You can then work out how many pages it is, and you can number your early conciliation certificate, say item number 1 will likely be then say page 4. And that means the judge hasn't got to have open separately an index and the bundle. And when they want to click on or put the numbers in for the early conciliation certificate, they haven't got to go, hang on, how many pages were the index? Right, okay, so that's page 4. They can just go to page 4. Or when I'm saying, if I can refer you to page 100, I'm not having to say, if I can refer you to page 100 of the paper bundle, which is page 104 of the electronic bundle, which I've spent the last 6 months doing in most cases, because this hasn't been ordered, but it's starting to be ordered now, that will make life so much easier and make the advocacy flow so much more smoothly. You will be asked at a lot of tribunals to send electronic bundles and paper copies. I'd assumed the reason for this, and a judge told me recently that my assumption was correct. It's that when you have wing members, they are mostly working from home, and so you need to get the paper bundle in time to be able to be sent out to them at home. The judge may use the paper bundle, but if they get the electronic bundle, they may start sooner, and it really just depends on which judge and how comfortable they are with working electronically. But there is a good reason you're being asked to do this. And I think it is a bit of a stretch to be asking tribunal panel members who only do this part-time to be working electronically. I don't know what sort of equipment they are provided with, but it's a lot easier if they've got a paper bundle. I did have a judge recently when I can only assume we were in the Southwest because we were given page limits and word count limits. We've got a case where disability is still an issue, but we're lifting it through to a final hearing now, whilst we're awaiting the Section 6 statement and medical disclosure. And so the judge said, do a core bundle. I think we've probably got 200 pages for it. And he said, don't worry about it being chronological. It's just that I want the core documents available to me. I don't need to scroll through 100 pages of a policy or set of policies before I get to the investigation minutes, because they're actually what I want to see. So you can cut down what's in the policy, but actually it doesn't necessarily have to come first, because we're just trying to make it much easier that when the judge opens the bundle or opens the bundle, what they really need is there. And he then said, have in a separate bundle all the medical documents. So if you've got problems with file size, like Sam was describing, that might be a better way to do it, whether it's fit notes, whether it's medical records, whether it's policies. It may be that you want to put that in a separate to the core bundle, and then that could make it a lot easier again for moving around it both paper-wise and electronically. So they're the main points I wanted to cover that Sam hasn't covered already, because he has really hit all the nails on the head. I'll just quickly answer the first question we've had come in on the Q&A, because it flows from these topics. So we've been asked by Paul Grindley. He's got a 3-day hearing in Leeds ET starting on 1st of June, so before all restrictions are lifted. Both he and his opponent would prefer an in-person hearing. Is it worth requesting that? Most of the participants will have been vaccinated, and one of the witnesses is in the mid-80s, hard of hearing and not conversant with IT. It's absolutely worth asking, Paul, but you're going to need to explain what you want and why. And what I would suggest you do is not just ask for a blanket in-person hearing, or not only ask for that. You might want to ask for that, but then put forward an agreed proposal for a hybrid hearing, because it's not just about the safety of the witnesses, it's the safety of the court staff as well. And that therefore means they're limited in terms of the number of people that can attend tribunal. I was in Leeds, I think it was this side of the new year, but maybe it wasn't. If it wasn't, it was just before Christmas. So whilst being under some pretty strict restrictions, and there was more than one trial going ahead, but I think there was maybe only 2 or 3. Anyone who's been to Leeds Tribunal knows that there aren't many waiting rooms. So they're having to use some of the hearing rooms for waiting rooms. And one of the hearing rooms has been opened up with the bifolding doors and is huge. Didn't help when the claimant started coughing. And me and my co-respondent counsel were extremely alarmed, and we all got sent home and carried on by CVP. And everyone was okay, luckily. But you'll recall that they have quite a narrow corridor for everyone to go down. So you've all got to be moved at different times, depending on the number of people you're bringing, depends on how many contacts there can be, etc. So if you want both representatives there and you want certain witnesses there because they can't deal with CVP, that's an absolutely fair request. And the sooner you make it, the better, because not all hearing rooms have CVP capability, or they won't be expecting all hearings to go ahead. So there's capacity issues. But if you just say we'd rather it's in person and we want everyone to attend, the tribunal is less likely to be persuaded, or more likely to come back to you and say, well, hang on, we can't have that many people, or how many people are going to be there. So put your proposals forward first. And that's how I envisage most in-person hearings going forward for the foreseeable. But absolutely no harm in asking. It's not a blanket ban against it at all. There just needs to be a good reason to go ahead in person. And it sounds as though what you've described is a good reason for reps and that one particular witness to be there.
Yeah, and I think Chloe's question that she's already also put in, which is the same sort of issue, but in the context of somebody having a disability. I mean, these are the sorts of things that are going to be of interest to the tribunal. But when it comes to disability, the tribunal has a duty to make reasonable adjustments in the same way that employers do. So it will be thinking about the same sorts of tests. You know, why does this particular disability create an impediment to dealing with CVP? And we probably need to explain that, and may well need to do so with medical evidence. Again, if you can agree the position with the other side, that's certainly going to help. But I think what's interesting, and the both of these queries are moving into what should be post-lockdown, which is actually our next topic. You know, what do we expect over the next 12 months? Well, I think at the moment, as we say, everything CVP. That's what the guidance says, pretty much, unless it can't be, and it quite often be postponed if it's not. But just as Laura said a moment ago about judges will have their own preference about whether or not they use a paper bundle or a paper bundle or a electronic bundle, I think what we're starting to see is judges showing their hand about what their preference will be in the future. So yesterday, a colleague in Birmingham had a hearing listed for March 2022, and the judge sounded adamant that CVP is here to stay. This will be a CVP hearing. It's just assumed that it will be. Conversely, I had a hearing last week where we listed in London for July for a in-person preliminary hearing. Sorry, for a substantive preliminary hearing, And that judge's view was, well, hopefully by July, we'll be able to do it in person, and actively hoping that we will do it in person. Now, of course, whether it's in person or whether it's CVP, at the preliminary hearing stage, may well be an issue of case management. Of course, judges have discretion on case management. Now, the president of the tribunals will obviously issue some new guidance over the next few months, and that should give us an indication. Equally, regions, they tend to differ as to what the norm will be. And similarly, it's not going to be unlikely that close to the hearing, we're told it's one way or the other because of capacity reasons or whatever it might be. But I think over the next 12 months, what I'm expecting to see is certainly CVP is here to stay. The question is, to what extent is it standard operating procedure, and to what extent is it available if required? And as I say, my experience, Laura, I don't know if yours is the same, is that really at the moment that seems like it's a little bit up in the air, but also seems like it's to some extent up to the judge's preference as well.
Yeah, absolutely. I'd agree with that. And I think we are getting those indications. There will be an element of politics to it. And I don't say that in any untoward way. But of course, the more that's done online, the more of the court estate the government will be able to justify closing. So there will be a need to keep doing some hearings in person, because sometimes that's needed. And if we're not doing enough, we'll lose the space, is my assessment of the situation. But I think coming back to Chloe's question, it's also about preferences of individuals, because I found in mental health cases or individuals that have developed mental health conditions, they don't all necessarily want to be at a hearing in person, or if they do, they maybe don't understand what the CVP option would be like. I've had some people who would much rather not attend, and others who have said, no, I want to be here, I want to see what's happening. But it strikes me, if they understand they can sit at home with somebody sat next to them as a support, obviously not giving their evidence for them, or if they understand they can go to their solicitor's office, or do it in the workplace if they're still employed, those sorts of options. I think it is worth, if you've got someone raising this, discussing all of those options with them to find which they are most comfortable with. In terms of July 2020, Chloe, I think hopefully you should be okay in Manchester. It's really about letting them know far enough in advance that there's a reason why you want an in-person hearing and how many people are going to need to be there, as opposed to how many people could still attend by CVP. I listed a case for sometime next year, I can't remember when, but say spring next year. And we were talking about what was necessary, what was possible on CVP. And there wasn't necessarily a clear answer as to what certain individuals would be able to do in terms of technology. And so we've just put in a direction that we'll write in with an agreed position 1 month beforehand. And the judge has already booked us the CVP space, because it must be one of the smaller hearing centres, to make sure that if we do need it, that room is available to us. So you can ask for that. And it's certainly something that has come out of lockdown, is practitioners and judges are working in so much more of a collaborative way than they were before to try and keep things moving. And it's just about giving the judge the information they need to be able to make the decision that you're asking them to make.
So Laura, we've got to give a CVP verdict, and our terrible acronyms are creating various problems or compelling virtual progress. Where do you fall?
I mean, it's like everything these days, it's a spectrum, isn't it? I would move towards compelling virtual progress on the spectrum, and I would say we're continuing to move in that direction as we iron out these issues.
Yeah, I think that's got to be right. I don't think I've seen much in the way of people who've done a fair bit of CVP that don't say, look, this is fundamentally a good thing. Yes, there are issues to iron out, there are challenges, there are problems that arise, but it's brought the tribunals into the 21st century in a way that I think might be something of a silver lining as to what's been a very tough year. So we're a little bit behind time, but let's think about some of the issues about relating to COVID that we've dealt with. So I've thought a few areas. So I think what COVID has done has shone the light somewhat on some neglected areas of employment law, certainly as far as appellate authority goes. So particularly things like health and safety, and to a lesser extent, the relationship between some aspects of working arrangements and disabilities, particularly thinking about auxiliary aids, which I think is a rare one, but does tend to come up more so now. On the health and safety side, we've had the Employment Rights Act a lot longer than I've been practicing, over 20 years, but there's very little law that exists on Section 44, health and safety detriment, Section 100, automatic unfair dismissal, health and safety, which are effectively the same thing, but one's a dismissal, one's not. And there seems to be a gap in the authorities about a critical question, which is when you are in the remit of Section 44 or Section 100, so you're in the circumstances where there is danger which is reasonably believed by the individual to be serious and imminent, and they've taken steps, reasonable steps in the case of 44E and 100E, which effectively results in saying, I'm not working, or I'm going home because I think I'm at risk. There's a bit of a gap as to whether in that circumstance somebody is entitled to be paid when they haven't come to work or when they have left work. There was a case that's been circulated a bit from 2014, Edwards and Secretary of State for Justice, which wanted to touch on this point, but ultimately got remitted for a separate issue and was never resolved. And there isn't clear and directly applicable authority about that point. And I think it's a really difficult question. And I've seen lots of legal commentary about it, and there are sensible competing views, because on the one hand, you might say, well, if somebody's effectively AWOL, the reason I'm not paying them is because they're AWOL. It's not because they've got health and safety fears. But on the flip side of that, when you look at the wording of Section 44 and Section 100, the detriment is because they left work. And so you're not paying them because they left work. So I can see that there may well be a right to be paid, and it may well be a detriment, and it may well be a constructive dismissal if they're not. It's a really difficult question, and I'm sure that we will see appellate authority on it. Unfortunately, I was due to have a hearing a couple of weeks ago where we touch on this issue, but it settled on the morning, so I didn't get to make my careful submissions about it. I won't tell you which side of the line I fell down on that particular example, but I'd be quite happy to argue it either way. I think a similar related point to that is not wanting to come to work or refusing to work or something like that in the context of reasonable adjustments, particularly mental health, because you can have, of course, a situation where mental health manifests itself in a fear, and it may well be that that fear means I'm not coming to work, even in circumstances where it seems like the guidance has been followed. And employers, particularly big employers, are held to a high standard when it comes to reasonable adjustments or things like that. And I think that's something that we're going to see tested a lot. I think the other area that I saw a few times as a solicitor, haven't argued it as an advocate yet, is challenges relating to redundancy in the context of furlough. Of course, furlough was effectively a brand new word about a year ago, and if somebody said furlough, they were probably thinking horse racing and just getting the word wrong. But furlough, there was certainly an impression, and an understandable impression from employees or former employees, that it's no cost to the employer. So if you need to make people redundant, just put me on furlough. Now, we know it's not quite right that it's at no cost to the employer, but it is clearly an alternative in some circumstances to redundancy. I think generally speaking, if we're just dealing with a normal redundancy, we're applying the band of reasonable responses test, it's probably going to be unlikely that someone would succeed with an unfair dismissal claim simply on the basis that they could have been furloughed, because what that would be doing is the Employment Tribunal stepping into the shoes of the employer, and of course they can't do that. I think you probably need more, and I think it needs to be something like an individual being targeted, or maybe it's related to a protected group or whistleblowing or something like that. So it's not so much the band of reasonable responses test, it's not so much that you could have furloughed instead of redundancy, it's why didn't you furlough? I think those are the sorts of things that I have seen, and those are the sorts of things that I think we need appellate authority on. Now, when it comes to the appellate side, obviously, as advocates, we tend to be a year or more behind the curve of the issues. You know, that's what the solicitors are dealing with, the lay clients are dealing with. It takes quite a long time. Just to exemplify that point, I did a bit of a search on the EAT decisions online register, search for COVID. There were 13 decisions, looked at all of them, but they were all just, well, this hearing was done by CBP because COVID, or, you know, we couldn't do XYZ because COVID, or whatever it might be. So I did the same search. There isn't anything basically in terms of good appellate authority and what we need. Did the same search in terms of Employment Tribunal online register, and there were 969 decisions. I didn't look at all of them, I'm afraid, but I did try and narrow it to things on the boxes that you can to see ones that might have been interesting. And the reality is the big interesting points, the big interesting cases on health and safety detriment, PPE, vaccines, they haven't made their way through yet. There was a case on PPE recently, which you might have seen, which was Cubilius and the Kent Foods, which is a case where a delivery driver refused to wear a mask when he was at a customer site. That was the rule. The rule was he must wear a mask. Customer was annoyed about it. So that engages with some of the concerns about COVID-related issues, but ultimately, there's no need for appellate authority on that sort of thing, because really that's just a misconduct case. And I think a lot of the issues that arise from COVID are going to be dealt with in that way. You know, our rules are X. If you don't follow the rules, you're going to be disciplined. And as long as the misconduct decision is within the band of reasonable responses, it's difficult for the tribunal to go behind that. What the interesting cases are going to be is where there's something else related, you know, the disability that's related, or, you know, you can't have a vaccine because you're pregnant, and how does that have the interplay and those sorts of things. Those are the interesting cases. But as I say, my view, and I think what is the case as at a year after lockdown, is we're just not there yet. Laura, anything in particular that you think is coming that you think we need to know from the appellate authorities?
I think not necessarily from the appellate authorities, as you say, we'll get there when we get there. And I would suspect if we're going to get there, it may well be union cases, because it's low paid workers in the gig economy who are the ones that have been working on the front line, leaving aside the NHS, throughout the pandemic, and they're not necessarily the most likely to bring claims unless they are done as group actions and union cases. But we will see what's raised when it comes up. Couple of points on what you've just raised and some additional thoughts. Health and safety, I think it's not just about COVID. We're all working from home, and I'm sat here with my newly acquired tennis elbow band on, my new ergonomic keyboard, which I'm so slow at typing on, apologies for any typos and emails you get from me, and my yoga mat on the floor behind me, because I've just been working in a really poor manner on my iPad without all of these additions. And so I'm now trying to remedy the physical effects. And that could well be the case for lots of people working from home. Now, you can't go to people's homes and do these assessments, but you're going to have to give them the opportunity to have what is needed. And there may well be issues of, well, actually, should you have identified that back problem had become a disability before you actually now accept it had, and that sort of information and opportunity for adjustments is being made available to staff working from home, particularly where they're going to stay working from home. But it's been a year already now, and we know some of those changes are going to be permanent. So I can see disability cases arising that way, or potentially constructive dismissal ones, even if they don't amount to a disability. So that's something to be aware of on an advisory basis, as I'm sure you all are. On the two main points that you'd raised, I think in terms of the detriment and dismissal points, and this overlaps with the fear that you were talking about on a mental health perspective, it's going to intersect with personal injury work, and what do we look at as risk assessments being completed, etc. If someone is working in a care home and the care home has fulfilled their duty of care, taking all the reasonable steps that they can do, etc., in order to make it as safe as possible to work there, they can't necessarily then go on to force people to have vaccines. I would think probably they can't at all. But therefore, you're looking at, well, is the refusal to work and to not be in the workplace reasonable? Is that fear reasonable to not be in the workplace? And that will feed in on a mental health disability case to whether it's a reasonable adjustment to pay someone for not being in work. And if you are still having to put steps in place for health and safety, results of a risk assessment, etc., then it may be whilst you are fulfilling that. But if it's just generally someone doesn't want to work because they're scared of COVID, full stop, then I think different considerations would apply. I have had the issue of furlough come up in redundancy, and I've had the tribunal give it pretty short shrift. I don't think it's actually a point where I've ended up with a decision on it, because that's not been something that's been fundamental, but I have had opponents on the other side fold on it fairly quickly in the face of the tribunal expressing that's not really going to change a genuine redundancy situation, for example, a restructure where 2 roles are going down to 1. If it's a case of a diminished amount of work as a result of COVID and that work may increase in the future, I do think it could come into whether dismissal is within the range of reasonable responses or whether furlough should be taken as another alternative. And you're going to need fuller financial evidence than we usually give, I would say, to explain why in your situation it wasn't reasonable for you to continue to incur the costs of furlough, national insurance, etc., as you would still need to be paying, as opposed to dismiss. So it's not to say that it would be an unfair dismissal, but you're just going to need to go into that more in the evidence than you might ordinarily with alternatives. In terms of the 2 points that I've seen raised, COVID and the pandemic has come up in time limits cases. Certainly where it's been an issue on behalf of a respondent, it's always been accepted, but it's not that unusual for respondents to get extensions of time in any event. Where it has been raised in presentation of claim time limit issues, I've had it come up on both unfair dismissal and disability just an equitable basis. It's not necessarily been treated any differently because it's all fed into the factual matrix of the situation, and I've not found yet it's been determinative. It is certainly a persuasive factor when it comes to just and equitable extensions, but given the ebb and flow of lockdown restrictions, and that we are probably past the worst of those sorts of lockdown restrictions that we had from March last year, I would suggest it's unlikely to be a determinative factor in cases in the future. But if you are faced with a COVID lockdown restriction case, don't be afraid to take the point and be pretty robust in challenging the other opportunities for the individual to bring a claim. It may not get you home on the just and equitable point as a respondent, but it is likely to help you on an unfair dismissal. And I personally found once you start cross-examining on it on a just and equitable point, you can uncover more features that then support your submissions. Same goes if you're for a claimant. Don't just say, oh, it was COVID lockdown, I couldn't do it, or I was having mental health issues because of lockdown. You're going to need to explain more. It's not a given that that would be grounds for just an equitable extension. And reasonable practicability, we all know how hard that threshold is to meet. Where it's been an issue in terms of staff in the office, if something has been missed, etc., have a look at what Harvey on Industrial Relations is saying about this. There are some updated sections, but actually once you dig into it, in terms of deadlines being missed because people weren't in the office, there's at least something to go on, so you can make a case on reasonable practicability, not just an equitable extensions. And ultimately, it can still be worth having a go. But I've not had one get past me advising on it and going all the way through to a hearing yet. Similar points come up in the other sphere where I've seen this, which is remedy decisions. And I had this very recently in an unfair dismissal claim where we actually did roll up liability and remedy. And in fact, we're in front of Brian Doyle. So if you expect anyone to get it right, you expect him to get it right and to deal with it succinctly, which he did. And we didn't get on to remedy because we succeeded in defending the unfair dismissal. But there the claimant was saying, well, I lost my alternative employment, which I'd only had for a couple of months and was temporary shortly before lockdown. Well, it was a good month. So there's your first point. And then I couldn't find, I didn't find alternative work because I was shielding, because I have asthma. But he had no evidence of a shielding letter, no evidence in relation to his asthma, and he held up one of those blue Ventolins, which I have for if I go running. I have exercise-induced asthma. Doesn't mean I'm further up the list on vaccines or anything like that. He has had his vaccine now, but I was again able to probe what had he done during other areas of lockdown when it had reduced, and he did disclose he'd got a driving job and then decided not to take that forward. So that was pretty much a nail in the remedy mitigation coffin for him. And then you can unpick the evidence in relation to shielding, etc. So it's one where the advice would be for claimants putting forward cases. Again, you're going to need to go into this in detail. You're going to need to look at, okay, what did you or didn't you or could you or couldn't you do during the first lockdown? How did that then change during the summer? What were you restricted in doing? What might you have looked for if you weren't restricted? Because we often look with lower paid work for supermarket work, delivery driver, etc. But of course, they have particular risks here. And so mitigation is all about what's reasonable. And you will need to explain clearly in your evidence why you say you have reasonably mitigated your losses by doing what you have done, and therefore why it was reasonable not for you not to do more, even when lockdown had lifted last summer, for example. And so that would be the same now in terms of lockdown restrictions lifting. If you are looking for respondents at evidence of a failure to mitigate, bear those points in mind. What work reduces contact with members of the public? Because you may find that in cross-examination they will say, oh well, actually I couldn't because I'm looking after an elderly grandparent and therefore I couldn't go and work on the tills at Tesco, for example. So try and maybe look for a bit of a wider sphere of work than you might otherwise do. And for claimants, again, explain why you can't do that if that is the case. Be clear and try and get some documentary evidence which supports it, in particular medical evidence. Time limits, it's likely to continue for a short period of time, but the remedy issues, given the delays that we've had, I think will continue considerably. And whilst we have a roadmap to a complete reopening, we don't know what's going to happen once we've all had our vaccines, whether we're going to need to continue to have boosters. What we do know at the moment is people who've had both vaccines, for example, the elderly, aren't being told you can go out and go about your day, it's all okay. And this comes back to the point before of attendance in person at tribunal. Just because you've had the vaccine doesn't mean you're not carrying it on your clothing into somewhere. So I don't think these are issues that are going to go away anytime soon in terms of actual issues in the case.
Yeah, we've had a question about vaccines, and we did say that we'd touch on vaccines in our flyer. I mean, vaccines is obviously an issue that I think over the next 12 months is going to be very, very interesting. You've heard a lot of stuff in the media about this. There's been lots of legal commentary about it. And this is probably one of the areas that I think we do need, certainly Court of Appeal, maybe Supreme Court authority on, because of the relationship in the engagement in the human rights, particularly Article 8, private life. I think I tend to agree at the moment with most of the legal commentary that I've seen, that it's going to be very sector specific and indeed role specific. But ultimately, it's effectively a question of proportionality, and that is proportionality in all the circumstances. So it's not difficult to see that in a clinical environment with close contact care with vulnerable people, a policy of you need to be vaccinated, or perhaps you need to be vaccinated or otherwise wear full COVID PPE is not justifiable. Clearly, very much depends on the circumstances and whether or not there is a more proportionate way to achieve the safety for the patients that are being treated. On the flip side, it's not difficult to see how a building site where people are being shot with blow darts with vaccine is not going to be justifiable. Clearly, it depends in those circumstances, and the position may well be different. Certainly contractual position may well be different for new hires and existing employees. I think the engagement between those sorts of policies and human rights and the principles as to where the line should be drawn, although it's fact specific, I think is something that we need appellate authority on, but we don't have. But I think that firstly, sector is probably the most important thing. Secondly, role. And thirdly, what are you trying to achieve? And is there another way to achieve it? We're pretty much at the end of our time. Please do put in any questions if you've got them. Laura, anything else that you thought would be helpful to share about the last 12 months and the next 12 months?
Well, I'll just address Ewan's question in a little bit more detail, because I think he's referring to something I said before about care homes, and whether I can expand on saying, So he said, had I said that a care home to hold itself out as a COVID-safe workplace would impede its ability to justify policy on mandatory vaccinations for its staff? Well, Sam certainly answered that in terms of proportionality, but of course, this is a sector where we'll particularly be looking at it. And you're going to need to look at things like, is this an NHS care home or local authority care home and therefore a public body? Is it a care home where people are held on grounds of capacity, and therefore even if a private provider does, human rights elements come into it? And you're also going to need to look at factors such as, is the refusal to have a vaccine either on grounds of religion and belief, or could it arguably be linked to another characteristic? And therefore you get into, again, proportionality, section 15, if it's disability, indirect discrimination, if it's any of the others protected characteristics. And there could, although there would have to be clear evidence, be some arguments on the basis of direct discrimination. I think it probably would come still more under indirect. If you look at the statistics for the, for example, ethnic group differences in vaccination take-up, all of these factors are going to come into play. But in terms of what you are asking an employee to do, and whether that is affected by your other provisions that you have taken in terms of making it a COVID-safe workplace, that's bound to come into play. Because is there a need for mandatory vaccinations is going to be affected by how much you can control COVID in the workplace. For example, the risk to patients or residents in care homes is going to be a factor in that. I think I was talking about it more on the flip side of an individual saying, I'm not going to come into work, where you could say, well, look, we've made it a COVID-safe workplace. We've done all that we reasonably can. And therefore, whilst you can refuse, we don't have to keep paying you because there is nothing more that we can do. And this is the workplace in the situation that we live in. And therefore, if it came into a disability claim, whether you would need to pay someone as a reasonable adjustment, well, is there any more that you could do? And you would be wanting to say, no, there is no more that we could do to make the workplace safe. Then again, your mandatory vaccinations might come into play because of, is that more that you could do? And you're going to be looking at that human rights interplay there. So you're really going to need to look on the facts, and it's not going to be purely a case of this is a care home and therefore one size fits all as an answer. But those are the sorts of factors that are going to need to be considered. In terms of 12 months, where we're going from now, this is going to be a fundamental question, and this is a question that I would expect somebody will take to the Court of Appeal to get some definitive guidance on, and I would suspect that if they do, they'll get an expedited appeal on it. To be frank, one can only hope that we do get an expedited appeal to try and provide some guidance, and that the Court of Appeal doesn't just do what I said and say it's all fact specific, but that is, of course, a risk. Where else are we going? Well, definitely still to working from home, I would say. Maybe predominantly, certainly for solicitors, it would seem. For us as advocates, there's going to be a fair mix of it. I would like to get back to hearings in person, but I also like the idea of there being a mix of working from home. I'm quite happy to go and make my bacon butty now rather than have to go and find the nearest prep to buy the same salad that I always buy. But I'd really like to see people as well. So I hope it will move towards a hybrid, and I suspect that is what will happen.
I think that's got to be right. And yeah, and I think that's probably what most people are looking for as well. And of course, what that would mean is that our panel of attendees, which has dwindled a little bit, but they've stuck with us for most of it, we might be able to see you over the next year, which would be great if we can do that. Any other questions, do fire them in, but we're about 10 past 2, said we finish at 15:15. If you've got any particular questions for us, please do send them through. We're both clerked ably by Paul Clark. I'm sure you've got our contact details. I'm very happy to talk through these issues, share experiences. And as we started by saying, in this evolving environment, I think sharing knowledge, sharing experiences is probably the way that we prepare and ultimately achieve what we want to, which is learn and then prepare better for the next time. So thank you very much for everyone this afternoon. Doesn't look like there are any more questions. Really appreciate you taking the time to speak to us. I think there will be a recording sent around at some point if you want to. Do get in touch if you want to. Thanks very much.
Thanks very much, everyone. Hopefully see you for a drink in the near future.